Workplace harassment regulations. Are you in compliance? This video has been produced by the Occupational Health and Safety Division of the Workers' Compensation Board of Prince Edward Island. It is our goal to assist island businesses in complying with workplace harassment regulations. Every worker has a right to a healthy and safe workplace. Employers and workers both play roles in creating and maintaining a positive and respectful work environment. In today's workplace, not only are employers responsible to protect the physical safety of an employee, but also must consider the psychological health of their workers as well. A psychologically healthy and safe workplace promotes worker psychological well-being and actively helps prevent harm to a worker's mental health. Workplace harassment is a psychological hazard that, when not addressed, can undermine a person's dignity. Workplace harassment can lead to negative outcomes such as increased risk of accidents and incidents, increased absenteeism, increased turnover, increased stress, decreased productivity and motivation, decreased morale, poor customer service, costly legal expenses. So why should you, as a business owner, care about workplace harassment? The fact of the matter is, harassment hurts business. In a toxic work environment, creativity suffers, performance and team spirit deteriorate, and customers turn away. Harassment creates unnecessary legal issues, and managing incidents can be expensive. Perhaps most importantly, this negative behavior damages people. The OHS Act and Workplace Harassment Regulations outline the rights and responsibilities for employers, workers, contractors, and other parties present at the workplace. It defines workplace harassment and includes responsibilities to prevent and address this workplace hazard. What is workplace harassment? The Workplace Harassment Regulations define harassment as any inappropriate conduct, comment, display, action or gesture, or bullying that the person responsible knows or ought to know could have a harmful effect on a worker's psychological or physical health or safety. Many employers think harassment doesn't occur at their workplace. After all, we do our best to respect others and be mindful of other people. Still, according to Statistics Canada, workplace harassment affects 1 in 5 women and 1 in 8 men. Keeping in mind that women are twice as likely as men to report physical violence and more than 5 times as likely to report sexual harassment. Judging by those numbers, harassment is a lot more common than we'd like to admit. Some examples of harassment might include vandalizing personal property, sexual remarks or advances, inappropriate jokes or images, verbal aggression or insults, spreading gossip or rumors, unwanted gestures or remarks. It's crucial to remember that intent alone does not determine whether a behavior is harassment or not. A person cannot excuse their behavior by saying they didn't mean it that way. I'm a manager. Does this mean I won't be able to manage? All reports of workplace harassment should be taken seriously. However, not every unpleasant interaction or workplace conflict is considered workplace harassment. For example, if a worker is constantly texting during a shift, it is perfectly fine to talk to the worker about inappropriate cell phone use. Expressing differences of opinion, offering constructive feedback, guidance, or advice about work-related behavior, if undertaken in an appropriate manner, is not considered workplace harassment. That said, it may turn into harassment if steps are not taken to resolve a conflict should it occur. Understanding your role. Ultimately, you, as the employer, manager, or supervisor, draw the line for what is considered acceptable behavior in your workplace. It does not have to meet the definition of workplace harassment for you to address behavior that is unprofessional or unwelcome. For example, if a coworker makes a comment about their weekend activities, it might not be considered harassment, but it may be considered an inappropriate topic for work. Consider establishing a code of conduct to outline what is acceptable behavior in your workplace. When it comes to workplace harassment, every person has a role to play. You, as employers, must develop and implement a workplace harassment policy. Be certain that any investigations are completely confidential. Ensure that sources of harassment are identified and stopped. Take reasonable steps to remedy the effects of harassment. Prevent or minimize future workplace harassment incidents. Workers also have responsibilities. Workers must maintain confidentiality, cooperate in any investigations if required, treat other workers with respect, speak up when harassment occurs, and report harassment to the appropriate person as soon as possible. Clearly defining harassment in your workplace harassment policy is key to ensuring workers recognize unacceptable behaviors. It's important to note that there may be informal ways to resolve an issue, such as asking the person to stop the behavior or approaching a supervisor for assistance. With a clear workplace harassment policy and open communication, workers are more likely to speak up confidently early on. Your legal obligations. In order to be in compliance with the workplace harassment regulations, employers need to create a workplace harassment policy. A written policy provides managers, supervisors, and workers with a clear understanding of how to report workplace harassment and what is expected from the employer in addressing the complaint. Employers must make a copy of the policy readily available to workers and ensure all workers are trained and follow the terms established in this policy. Key components of a workplace harassment policy. An effective written policy defines what is appropriate, acceptable, and lawful business behavior. The policy should be relevant, concise, and explicit to ensure workers can clearly understand its intent. A workplace harassment policy is most effective when it is supported by all levels of management, clearly written so it is understood by all workers, applied fairly to everyone in the organization, readily available to everyone, and consistently followed when there is a workplace harassment complaint. As an employer, keep in mind that you are required to consult with the safety committee or representative, if any, to develop and implement your written workplace harassment policy. The following sections must be included in your policy. Number 1. Definition of harassment. Explain what is meant by harassment, including examples of behavior or actions that may be considered harassment at the workplace. Be sure this is consistent with the definition of harassment in the regulations. Number 2. Policy statements. A workplace harassment policy must include the following: a clear statement that everyone is entitled to work free of harassment. the employer's commitment to ensuring no worker will be subjected to workplace harassment, management's commitment that necessary corrective action will be taken to ensure a harassment-free workplace, and a statement that the employer shall not reprimand or discriminate against a worker who has, in good faith, made a workplace harassment complaint. Providing clear statements will help workers feel confident if they need to report possible workplace harassment. It can also prevent workplace harassment by sending the message that negative behavior is unacceptable and will not be tolerated. Number 3. Reference to applicable law. The policy must include statements that the employer's harassment policy is not intended to discourage, prevent, or preclude complainant from exercising other legal rights pursuant to any other law. The harassment policy does not preclude a worker from filing a complaint under the Human Rights Act. People in management positions, as well as those investigating and resolving complaints, should know it is not appropriate to discourage a complainant from exercising any legal rights. Number 4. Roles and responsibilities. All persons in the workplace need to know what is expected of them. In this section of the policy, describe individual roles and responsibilities. Include those that are consistent with Part 2 of the Workplace Harassment Regulations. Worker responsibilities should include treating other workers with respect, speaking up when harassment occurs, maintaining confidentiality, reporting harassment to the appropriate person as soon as possible, and cooperating in any investigation if required. Supervisor, manager, and employer responsibilities should include treating all employees, clients, suppliers, and contractors with respect, refusing to tolerate harassment. They must put a stop to it immediately. Dealing with harassment allegations seriously, speedily, and confidentially. Reporting or investigating all complaints. Ensuring the policy is readily available to workers. And addressing workplace harassment by identifying the source and taking reasonable steps to remedy the effects of the harassment. Number 5. Formal reporting and investigating procedures. The policy must establish procedures that clearly indicate how a worker can report a workplace harassment complaint. Creating a process to receive and investigate complaints in a consistent, fair, and effective manner is critical. While resolutions can be informal, it's your duty as an employer to ensure all complaints are always formal and well documented. Your policy must also establish a process for reporting workplace harassment which addresses the following: how to make a complaint to the employer, how to make a complaint when the employer or supervisor is the subject of the complaint, how investigations will be conducted, how the results of the investigation will be communicated to all parties. You are required to include a policy statement that, as an employer, you will not disclose any identifying information about any person involved or the circumstances relating to the complaint. The only exception is if disclosure is necessary for the purposes of investigating or taking corrective action or permitted by law. Your policy should make it clear that complaints are to be made in writing and include the complainant's signature. The policy should also state that an investigation may be conducted and that the employer will refer the investigation to an impartial person, which could be within or outside the workplace. Workers will have an increased sense of confidence in the process when the policy shows your commitment. This means ensuring that investigations will be undertaken promptly and diligently and be as thorough as necessary. Be fair and impartial. Be sensitive to the interests of all parties and maintain confidentiality. Be focused on finding facts and evidence, which should include interviews with the complainant, respondent, and relevant witnesses. Number 6. Education and policy monitoring. Consider the type of support your organization will provide to ensure workers are well educated on workplace harassment. Your policy should identify how training will be provided to current workers, managers and supervisors will be trained to recognize harassment and address the situation appropriately, an investigator will be trained to perform the role, and you will ensure new workers are trained, in addition to ongoing workplace harassment awareness. The policy should be reviewed every 3 years, or as often as required to ensure it is up to date. It should also be adjusted accordingly, based on worker and management feedback, including exit interviews. Number 7. Corrective action and safeguards. Determine possible corrective actions that may be enforced in the event workplace harassment is present in the workplace. In addition, identify any safeguards that protect workers and submit a complaint in good faith. You should include the range of disciplinary actions that may be imposed on the harasser, information about whether the complaint will be included in the harasser's personnel file, information about whether the complaint will be put in the complainant's personnel file when the complaint is in good faith, and information that protects the victim and any involved workers against retaliation. Performing a workplace harassment investigation. Investigations are an important part of addressing allegations of workplace harassment and should be performed by you as the employer. When a complaint of workplace harassment is made, you should begin by requesting that the complainant submit details of the incident in writing. It can be helpful to provide a complainant with a complaint form. For a sample complaint form, see Appendix B of our Guide to Workplace Harassment Regulations. Next, you must assign an impartial investigator. An impartial person is someone who is not directly involved in the incident or the complaint, is not supervised by the person who is a subject of the complaint, has knowledge of the Workplace Harassment Act and regulations, as well as other applicable laws. If an investigator is unable to obtain a written version of the allegation, they may set up a meeting to document incident details. Once the investigator has this information, they can properly determine if the allegations in question meet the definition of harassment. Interviews. When it comes to interviews, they should be conducted individually in a private area, ideally by 2 people. An interviewer should go over the investigation process with all persons being interviewed. The interviewer must inform all participants why they are being interviewed, what will be done with the information, and who may receive a copy. It is important to remind all interviewees that confidentiality must be maintained. Interviewees should sign a statement that they agree to keep the details and the circumstances surrounding the interview confidential. The interviewer should seek any information the interviewees may have and should ask interviewees to give as much detail as possible, but stick to the facts. If the person being interviewed is unsure about a matter, they should say so. To ensure fairness, the interviewer should always ask open-ended questions. At the end of the interviewer should review the information gathered with each interviewee. This will help to confirm the accuracy of the information gathered and allow for the interviewees to add any additional information. For more information on interview best practices, please see our Guide to Workplace Harassment Regulations. The report. Once all information is collected and interviews conducted, a report must be prepared detailing the findings of the investigation. Although writing styles may vary, the content of the report should include names of persons conducting the investigation, names of others involved and interviewed, the date, time, and place of the alleged harassment, a description of the alleged harassment, all graphics, photographs, and other related evidence. Findings of the investigation. Was it workplace harassment? A conclusion with recommendations for immediate and long-term actions. If harassment is found through the course of an investigation, it is you, the employer's responsibility to ensure appropriate corrective actions are taken. Reporting a workplace harassment complaint to Occupational Health and Safety. In all cases where there is suspected or known workplace harassment, the worker reporting the complaint should report to the employer. If you, the employer, fail to comply with your duties under the OHS Act, an Occupational Health and Safety Officer may investigate to determine compliance. An employer who knows, or ought reasonably to know, that harassment in the workplace is occurring shall ensure that the source of harassment is identified and reasonable steps are taken to remedy the effects to prevent or minimize future incidents of harassment. The officer's role. Where an officer has cause to believe an employer has failed to comply with its duties under the Act and regulations, the officer may issue an order in the following circumstances. The employer hasn't established a written workplace harassment policy that meets the requirements of Section 4. The employer established a workplace harassment policy that is inconsistent with the requirements of the Act and regulations. The employer failed to follow a workplace harassment policy in response to a complaint. The employer has failed to take reasonable steps to resolve a complaint. The employer has violated a provision of the Act or regulations with respect to prevention or investigation of workplace harassment. Please note, it is not the responsibility of the officer to complete a workplace harassment investigation. An officer's role is to ensure an employer has adequate policies, procedures, and training in place to address workplace harassment. Conclusion. This video has outlined the employer duties that must be followed to ensure compliance with the workplace harassment regulations. As employers, you have key duties to follow under the Workplace Harassment Regulations and the OHS Act. It is your responsibility to promote and maintain a positive workplace environment by complying with the legislations. By working together with your staff, every person can contribute to a tolerant and respectful work environment and an overall healthy work culture. For more information, detailed guidelines, and sample documents, please visit our website at wcb.pe.ca to download your copy of our Guide to Workplace Harassment Regulations. To learn more about other OHS topics, find our Guide to OHS Legislation app on Google Play and the Apple Store. As always, if you have any questions or concerns, please don't hesitate to contact the Occupational Health and Safety Division of the Workers' Compensation Board of Prince Edward Island. We are here to help.